organized by Amity Law School, Amity University, Madhya Pradesh. Today, we gather not merely for a competition, but for a meaningful engagement with very principles that shape our constitutions and democratic framework. We are overwhelmed with the presence of esteemed panelist Ms. Swati Pal, Assistant Professor, IPEM Law Academy, Ghaziabad. Her valuable time for judging the preliminary round of the debate competition. The topic for today's debate, whether the judiciary should have the power of judicial review or not, is both timeless and highly relevant. It reflects a question that has been central to the constitutional governance, the balance of power between the legislature, executive, and the judiciary. Before we begin, I would like to briefly outline the rules and structure of the competition. All the speakers shall be required to mention their participant code strictly at the time of the competition. Each participant will be given 8 minutes to present their argument. A warning bell will be given 1 minute before the conclusion of the time. Participants are expected to maintain decorum and adhere to strictly to the allotted time. Rebuttals, if applicable, should be concise and respectful, and the time will be 2 minutes. The decision of the judge will be final and binding. I request all the participants to present their arguments with clarity, confidence, and respect for opposing views, keeping in mind the essence of democratic discourse. With this, now I declare the debate competition open and invite our first speaker, that is CADC02, to present their argument. Thank you, and I wish all the participants very best. Now I welcome CADC02 for the deliberation. Your time, CADC02, please open your camera and mic. Please open your camera as well. CADC02, your time for 8 minutes start now. CADC02, you are not audible and your time has started. CADC02, you are not audible.
Hello.
Yes, yes. Now you are audible.
Am I audible, ma'am?
Yes, yes, yes. Now you are audible.
Yeah. Thank you so much. Apologies. A very good morning to honorable judges, chairperson, and my distinguished counterparts. It is often said that a constitution is not a mere lawyer's document, but a vehicle of life. But if I ask you, what uses a vehicle if it has no steering or no brakes? At the time of our independence, the framers of the constitution of our constitution did not is supreme law and with it a supreme guardian. I stand here today affirm that the power of judicial review was not a judicial grab or a later invention. It was the very soul of our founding document in the 1950. In the words of Chief Justice Kania, the judiciary was designed to be the senator on the Q vibe, the watchful guardian of our democracy. Let me introduce you briefly that in 1947, India did not merely change its flag, it changed its fundamental philosophy of power. For nearly 2 centuries, we lived under the shadow of colonial sovereignty, where the law was an instrument of the ruler to control the ruled. But on the 26th January 1950, we transitioned to constitutional supremacy. The question before this house is whether the judiciary possessed the power of judicial review at the time of independence. To this, I stand before you with a firm and unwavering. I contend that judiciary was power evolved or into our system over
Check your
decades.
connection because its voice is breaking. Your voice is breaking.
My connection is stable actually.
Okay, you can continue.
Mm. So rather, it was a power that was born fully formed within the very ink of a constitution. The framers of a nation, having witnessed the horrors, is a mere parchment prone fragility of human rights, understood a vital truth that a Bill of Rights is a mere parchment. My opponents might suggest that a young fledgling nation would prefer a supreme parliament to drive rapid change. But I argue that our founders were far more visionary. They knew that the will of the people can sometimes be hijacked by the passions of the moment. Therefore, they intentionally placed the judiciary as the Senate along the queue vibe, a watchful guardian stationed at the borders of our liberty. From the very moment of the Constitution was adopted, the judiciary was vested within the authority to say no to the state for the very first time. This was not an act of defiance, but an act of duty. Today, I will prove that without this power, our Constitution would be a body without a soul, and our democracy is a ship without a rudder. I will demonstrate through provisions and precedent that judicial review was a primary safeguard designed to ensure that in New India, the law would finally be the master of the man and not the man of the master of the law. So, if I start with that, what is judicial review? Let me give you a brief that what judicial review actually is. So, judicial review is the power of judiciary courts to examine laws, actions, or decisions made by the legislative and executive branches of government and determine whether they are consistent with the constitution or not. If a law or action is found to violate the constitution, the court can declare it invalid or unconstitutional. The concept was firmly established in the United States through the landmark case of Marbury versus Madison, and it also is an important feature of the Indian legal system under the Constitution of India. My opponents may argue that the term judicial review does not appear in the text. To them, I say look at the function, not the label. The Constitution is saturated within the power of review. As I would tell you some key provisions. First of all, I would tell you Article 13, which was the Golden Gate. It explicitly states that the state will shall not make any law that takes away or abridges fundamental rights. Any law that does so is void. Who determines the voidness? Not the parliament that passed the law, but the judiciary that interprets it. And now the another article is Article 32. Dr. B.R. Ambedkar called this as the heart and soul of our constitution. It gives every citizen the right to move to the Supreme Court directly. If the court has the power to provide remedy, it must be definition have the power to review the act that caused the injury. And Article 226, these vest the high courts with the power of writs. This was a direct inheritance of expansion of the powers held by the federal courts even before 1947. The key case laws for the judicial review were A.K. Gopalan versus State of Madras, which was the very first case in 1950. While the court took the narrow view of liberty in this case, Chief Justice Kania made it clear in India that it is the constitution that is supreme, and it is for the judiciary to decide whether any enactment of constitutional uh, enactment is constitutional or not. This was the Supreme Court's first official act declaring its own authority. And the First Amendment conflict 1951, the very fact that the parliament felt that the need to create the ninth schedule to protect land reforms proves that they knew the judiciary had the power to strike down their laws. You don't build a shield unless someone is holding a sword. The another case was that State of Madras versus V.G. Rao 1952. Justice Patanjali Shastri reinforced that judicial review is a duty cast upon the courts by the Constitution, on the temporary will of the majority. Honorable judges, as I draw my arguments to close, let us reflect on the gravity of the year 1950. India was a newborn nation, scared by partition and grappling with centuries of inequality. In such a violent climate, the greatest danger was not a lack of power but the abuse of it. My worthy opponents have attempted, sorry, but I ask you, who truly represents the will of the people? Is it a temporary parliament elected for 5 years, or is it the constitution? which was forged in the fire of the freedom struggle.
Participant, only
of
1
those
minute
centuries.
remaining.
When the judiciary had the power of review at the independence, we were saying that the rights are not gifts of the government. It is a citizen can, if a citizen can be silenced, if a minority can be silent, and if a state can be overborne by the center without any recourse to a court of law, then our independence is nothing but a change of masters from a British monarch to a local parliament. If you believe that a citizen should have been a shield against the state, if you believe that the law should be stronger than politician, and if you believe that the promises of 1947 were meant to be kept, then you must conclude that judicial review was not just an available power, but the absolute heartbeat of our nascent republic. The judiciary did not seize this power. They inherited it as a sacred trust, and it is this power alone that ensures that while the government may be the ruler of the day, the constitution remains the master of the land. Thank you.
Your time is over. Thank you. Now I request CADC01 to present their arguments. Please open your mic and camera.
Mom, shall we ask the question to C02?
No, now right now you present your arguments. Rebuttal time will be given afterwards.
Okay, mom. Mom, please tell when to start.
Your time starts now.
क्या ये वही देश है जिसका सपना सुभाष चंद्र बोस ने देखा था? क्या ये वही देश है जिसके लिए भगत सिंह ने अपनी जान दी थी? क्या ये वही देश है जिसके लिए हजारों लोगों ने अपना खून बहा दिया था? गुड मॉर्निंग रिस्पेक्टेड जजेस एंड ऑनरेबल अपोनेंट्स। आज सवाल सिर्फ इतना नहीं है कि सिस्टम चल रहा है या नहीं, आज सवाल ये है क्या वो सही डायरेक्शन में चल रहा है। When we go back to the constitutional phase of 1946 to 950, we are not looking at a legal document, we are witnessing the foundation of a nation built on the power of sacrifice. In the Constituent Assembly of India, one concern echoed again and again and again that how to prevent concentration of power. Because our leaders had seen the dangers of unchecked authority and they knew that democracy cannot survive when power is accumulated in the hands of one. That is why under the Constitution of India, Article 13 allows us, the judiciary, to strike down any laws that are fundamentally violating the rights of citizens. Article 32 empowers citizens, but at the same time, Article 121 and 122 ensures that the judiciary cannot intervene in the decisions of the parliament. In fact, Dr. Ambedkar mentioned that Article 32 is the heart and soul of the Constitution. This was not any confusion, ladies and gentlemen. This was not overlap. This was a carefully designed balance. And at that very time, India was going through massive transformation. Land reforms were being introduced, zamindari systems were being dismantled, and the state was being guided towards social and economic justice by the help of directive principles. The message that stated was very clear that reforms must happen and governance must function. डेमोक्रेसी का स्ट्रक्चर हमेशा से क्लियर था। लेजिस्लेचर कानून बनाएगा, एग्जीक्यूटिव इंप्लीमेंट करेगा और जुडिशरी इंटरप्रेट करेगा। लेकिन जब वो इंटरप्रिटेशन एक्सपैंड होके दखलंदाजी बन जाए तब वो मैनिपुलेशन ऑफ पावर बन जाती है। As we say in Sanskrit, जनप्रतिनिधिनां निर्णयः सत्तायस्य मूलम्. The decision of the people's representative is the foundation of democracy, but let us reflect that judicial review was never meant to dominate, it was meant to protect, not control. During the Constituent Assembly debates, leaders like K.T. Shah warned that the power should not rest in the hands of one. And similarly, Alladhi Krishna Swami Iyer emphasized that the judiciary must act as a check, but not as a replacement for governance. The farmers were very clear that balance was never optional, it was essential. But today, the question is, when judicial review, which was meant to be a shield, starts acting like a sword, when it stretches from protecting rights to influencing policies, from protecting laws to effectively shaping it, then are we still within the Constitution or are we slowly moving beyond it? If we look back at the Mahabharata, even the side of Dharma was not free from question. Lord Shri Krishna, the guide, the strategist, the one standing for righteousness, even had to step beyond conventional rules to ensure victory for Pandavas. But that is exactly the point of my speech. When even righteousness begins to bend rules, it creates a moral dilemma because once limits are crossed, justification becomes easy and control begins to slip. Similarly, when an institution meant to protect starts stretching its limits, it may justify it in the name of justice, but the real question that remains is at what cost to balance? So let's be honest, ladies and gentlemen, the Constitution never intended the judiciary to become a super legislature. It was meant to check excess, not to control governance. Even Dr. B.R. Ambedkar warned us, however much a good constitution is, if those who are implementing it are wrong, then it will prove to be bad. The question is not whether judicial review is necessary, the question is whether it is still under limits. Because in a democracy, power should not only be just, it should also be accountable. The real issue that arises is when an unelected institution repeatedly overrides the will of elected representatives without any direct public accountability, it stops being a safeguard and starts becoming a dominant power. लोकतंत्र किसी एक पिलर की डोमिनेंस पर नहीं, बैलेंस पर चलता है, और आज ये बैलेंस वीक नहीं हुआ है, ये डिस्टॉर्ट हो चुका है. Judicial review, as envisioned between 1946 and 1950, was meant to be limited, disciplined and corrective, but आज के समय में ये ना रिव्यू है बचा है, ना ये एक्सपेंशन है, ना ये एक इंटरफेरेंस है, और टाइम्स पे ये लुक लाइक कंट्रोल बनने लगता है. ये करेक्शन नहीं, ये ओवर रीच है और ये गलत है. आज भी से जिस आजादी के लिए लहू बहा था वो बंजर नहीं, चुनी हुई हुकूमत ही जमहूरियत का असली निखार है. भीड़ तंत्र की दहलीज पर लोकतंत्र ना टूटे, जनता का शासन ही भारत का सच्चा श्रृंगार है. लोकतंत्र किसी एक पिलर की डोमिनेंस पर नहीं, बैलेंस पर चलता है. ये लाइन बिल्कुल सही है, क्योंकि जिस देश में जनता ने नेता को ताज पहनाया है, वहीं कुछ लोगों ने हर फैसला रोक दिखाया है. चंद जजों की आवाज को यूं चंद जजों की राय पे क्यों ये देश चलाया जाए, करोड़ों की आवाज को क्यों कैसे भुलाया जाए. वो कहते हैं रिव्यू, हम कहते हैं सवाल. क्या 148 करोड़ लोगों से हो सकता है बड़ा कोई ख्याल? क्या क्या जनता से बड़ा हो सकता है कोई ख्याल? एक तरफ है वोटों की गूंज, दूसरी तरफ है कलम का वार. कौन है असली मालिक, ये बन गया सवाल हर बार. अदालत का काम था इंसाफ का रास्ता दिखाना, ना कि जनता की मांग को बार बार मिटाना. जब चंद लोग तय करें हर कानून की तकदीर, तो फिर जनता की ताकत लगती है अधूरी सी तस्वीर. आज भी से लोकतंत्र की मौत शोर से नहीं होती, संतुलन टूटने से होती है. एंड लेट मी आस्क यू अ क्वेश्चन. 1946 से 1950 तक इस देश ने एक बात तय की थी कि कोई भी संस्था जनता से बड़ी नहीं होगी. आज सिर्फ एक सवाल रह गया है, क्या हम उस वादे पर टिके हुए, जो कि बिल्कुल ही गलत है. हम उस वादे से बहुत आगे जा चुके हैं, क्योंकि अब जुडिशियल रिव्यू लिमिटेड नहीं अनलिमिटेड हो चुका है. वो अपनी लिमिट्स को भूल चुका है. जुडिशियल रिव्यू का काम था कॉन्स्टिट्यूशन को प्रोटेक्ट करना, ना कि उसे बार बार इंटरप्रेट काम में. एंड इफ वी लुक आउट एज अ ब्रॉडर प्रोस्पेक्ट, वो जो वहां पे कॉन्स्टिट्यूटेंट असेंबली के डिबेट्स में लड़ रहे थे कि हर नागरिक को उसका हक और अधिकार मिले, वो भी आगे के जमाने में सोचते थे कि क्या होगा अगर बाई चांस इसकी पावर बढ़ जाती है और हम इसे कंट्रोल.
Participant, only 1 minute is remaining.
That is why in the ending segments of my speech I would like to say, मुद्दा ये नहीं है कि जुडिशियल रिव्यू जरूरी है या नहीं, वो जरूरी तो है, मगर अनरिस्ट्रिक्टेड जुडिशियल रिव्यू हमेशा लोकतंत्र को तोड़ता है और डेमोक्रेसी का रक्षक की जगह उसको विनाश करने का एक प्रारंभ करता है. थैंक यू. जय हिंद, जय भारत.
Now I would like to call CADC02 for their rebuttal, if any.
थैंक यू मैम. मैं एक चीज पूछना
Your
चाहूंगा.
time starts now.
थैंक यू मैम. मैं एक सवाल मेरा है कि अगर भारत में सांसद बड़ी है, पार्लियामेंट बड़ी है, या संविधान बड़ा है. अगर संविधान बड़ा है तो सांसद द्वारा बनाए गए किसी भी कानून को जो संविधान के खिलाफ हो, कोर्ट क्यों नहीं हटा सकता? क्या आप कहना चाहते हैं कि आजादी के समय सांसद को मनमानी करने की छूट थी?
आजादी के समय सांसद को अपने डिसीजन
Participants, wait. You will be given chance one by one. CADC 02, please complete your rebuttal first. Then the chance will be given to CADC 01.
मैम सारे एक साथ पूछूं?
Yes, go in one hand.
और दूसरा क्वेश्चन ये है कि आजादी के समय बहुत से पुराने अंग्रेजी कानून चल रहे थे। संविधान ने कोर्ट को ये जिम्मेदारी दी थी कि वह देखे कि कौन सा पुराना कानून नए भारत के हिसाब से सही है और कौन सा गलत। क्या ये जिम्मेदारी बिना जुडिशियल रिव्यू के पूरी हो सकती थी? और अगर जो आर्टिकल 32 जिसकी बात डॉक्टर बी आर अम्बेडकर ने करी थी, ये जो संवैधानिक उपचार को संविधान की आत्मा कहा था, अगर कोर्ट कानून की जांच यानी कि रिव्यू ही नहीं कर सकता तो वे लोगों को अधिकारों की रक्षा कैसे करेगा? क्या बिना जांच किए न्याय देना संभव है? संविधान के अनुच्छेद 30 में साफ लिखा है कि सरकार ऐसा कोई कानून नहीं बनाएगी जो जनता के अधिकारों को छीने। मेरा सवाल ये है कि अगर सरकार ऐसा गलत कानून बना देती है तो उस गलत ठहराने और रद्द करने की ताकत कोर्ट के अलावा और किसके पास होनी चाहिए? क्या बिना कोर्ट की शक्ति को अनुच्छेद 13 सिर्फ एक कोरा कागज नहीं बन जाएगा? और यही ऐसा होना था तो इंदिरा गांधी वर्सेस राजनारायण 1975 केस में जो अमेंडमेंट आया था, वो अमेंडमेंट जो कि बिल्कुल अनकॉन्स्टिट्यूशनल था, उसके अगेंस्ट में कोर्ट ने अपनी पावर क्यों ली, जबकि वो पार्लियामेंट का निकाला हुआ एक एक्ट था? That's all.
CADC 02, your time is over. Now I would like to invite CADC 01 for their part of the rebuttal.
So, as you mentioned, Madison versus Marbury case of 1803 United States, if the Constitution is the supreme law, why does it not explicitly grants the Supreme Court the power of judicial review? By discovering this power, did the court actually overstep its bounds and become a policy-making body? And does giving unelected judges the final say on the constitutionality of laws passed by elected representatives undermine the principle of government of the people? Is it possible that the court's interpretation of Article 3 was intentionally narrow just to create a conflict with the Judiciary Act of 89 and seize more power? That's all.
Okay, thank you, participant. Now I request the esteemed panelists to mark both the participants. Ma'am, if the marking has been completed, I would like to call the next participant.
You can call, marking has been done.
Okay. Now I would like to call the participant number CADC 04. Please open your camera and mic.
Yes.
Wait a second.
Before I begin, Mrs. Upadhyay, ma'am, I just had a doubt.
Yes.
Ma'am, as we got to know yesterday, we cannot use any data after 1951.
Okay.
My original speech included the data,
Yes.
so would I be disqualified if I include that data?
It will be on discretion of the judge.
Okay, so what would Mrs. Pal say about that? Ma'am, your mic.
You can add on the data after that. No problem.
I can use that data, right?
Yeah, you can.
Okay, thank you so much,
Okay.
ma'am. Thank you.
Okay, your time starts now.
Bad laws are the worst sort of tyranny. Quoted Edmund Burke, and history has rarely proved them wrong. Honorable judges, fellow debaters, today I stand in favor of judicial review, not as a privilege granted to the judiciary, rather a tool to save democracy from itself. Because when power exceeds its limits, who determines that it has done so? Without judicial review, that question has no answer, and when there is no answer, power lashes out. So I ask you, is it wise to let the lives of 1.4 billion people depend on the goodwill of a handful of power-hungry leaders without any inspections? And if you disagree with me, ladies and gentlemen, allow me to remind you, if not for judicial review, on 24th of August 2017 in Justice Case Puttaswamy versus Union of India, the right to privacy would not have been recognized as a fundamental right under Article 921. If not for judicial review on 6th of September 2018 in Navteej Singh Johar versus Union of India, parts of Section 377 and colonial-era restrictions on personal liberty would have continued, and if not for judicial review on 15th of February 2024 in Associations for Democratic Reforms versus Union of India, electoral bonds would have continued despite violating voters' right to information under Article 19. This is not merely a lucky fluke, it is a set pattern where every time authority overflows and the judiciary has to contain it. Ladies and gentlemen, can democracy truly exist without checks and balances? Are we not depriving ourselves of rights and their enforcement by arguing against judicial review? And paramountly, are we not violating Article 13 of our Constitution, which states that all laws are inconsistent with or in derogation of any fundamental rights shall be void, implicitly providing the doctrine of judicial review? बार बार दशक दर दशक इतिहास ने सत्ता को संयमित होते नहीं देखा है, बल्कि न्यायपालिका को उसे संयमित करते देखा है, and that is the point. Even when we walk on a tightrope, we need a safety net. Even when we trust democracy, we need a safety net, and that role is played by the judicial review. Let us now change our lenses from constitutionalism to social psychology. Let me take you through space and time in the 2002-2003 session of the UK Parliament. On 18th of March 2003, the House of Commons voted to support the Iraq War under Prime Minister Tony Blair. Many MPs later acknowledged serious doubts, but those doubts did not translate into opposition when it mattered. This can be explained through Irving Janis's concept of groupthink, where highly cohesive decision-making bodies, especially those operating under strong leadership, tend to suppress dissent, overlook alternatives, and develop an illusion of unanimity. This can be further reinforced by what social psychology calls the authority bias, our tendency to trust authority without really questioning it. And if this happens in highly established parliaments like the United Kingdom, imagine the risks involved in a more complex, high-pressure system such as ours. Systematically, what this is at its core is dysfunction, and when such dysfunction enters governance, removing judicial review does not eliminate it, it amplifies it. Ladies and gentlemen, allow me to shed light on the not-so-well-known case of Shreya Singhal versus Union of India, where the government under Section 66A of the Information Technology Act 2000, as amended in 2008, criminalized sending offensing or menacing messages via computers or communication devices punishable with up to 3 years of imprisonment. Now, under Article 19, Subclause 2, free speech can only be restricted on certain grounds such as defamation, public order, security of the state, and so on. Terms used here, annoying, offensive, inconvenient, do not fall within these categories. Clearly, this law went beyond constitutional limits. The Supreme Court also deemed it excessively vague, stating that it would lead to subjective interpretation, trivial arrests, and, more pressingly, granting the police unchecked discretion. Finally, the Supreme Court struck it down, stating, and I quote, "It would have a chilling effect on free speech," meaning people would begin to self-censor out of fear, resulting not in the rule of law, but a rule of fear. And when a state trembles with the fear of law itself, it is no longer a democracy. It is the genesis of a dictatorship. Now tell me, ladies and gentlemen, would we truly remain unfazed by violations of Article 19, Subclause 1, Article 19, Subclause 2, Article 14, Article 21, Article 22, along with an indirect assault on the very basic structure of our Constitution? Let us move to something even more fundamental. The fact that the legitimacy of a law arises not from who passes it, but rather from how it is passed. Today, the productivity of legislative bodies is measured by the number of laws passed as opposed to the deliberation behind them. In the early decades of our republic, from 1952 to 1970, the Lok Sabha sat for an average of 120 to 135 days annually. Fast forward to the 17th Lok Sabha session, it sat barely for 55 days. Now, if you hand these numbers out to a layman, she would not need constitutional training to tell me what this means. It means deliberation is shrinking and scrutiny is being sidelined, and that is unacceptable because productivity today may be on its acclaim, but deliberation is at its nadir, and that is precisely why judicial review is indispensable. This becomes even clearer when we see that out of the 240 bills introduced in the 17th Lok Sabha, 45 bills were passed on the very same day they were introduced, leaving little room for sincere debate. We see a vivid failure of deliberation in the Shreya Singhal versus Union of India case as well. Here the real question unfolds. If human systems are capable of error, which history clearly shows they are, then is it not equally necessary to have a corrective mechanism built into that system itself? Ladies and gentlemen, it is beyond
Participant, only
reckless.
1 minute is remaining.
Ladies and gentlemen, it is beyond reckless to remove the very thing that stands between us and imprudent governance. If the inevitable lesson of history is that no one learns, then the question of the existence of judicial review must not be questioned. Because as James Madison reminded us, if men were angels, then no government would be necessary. Judicial review exists because humans and power do not restrain themselves. They never have, they never will, and without it, neither will tyranny. Thank you so much. Thank you, ma'am.
Thank you, CADC 04. Now I would like to call CADC 03. CADC 3. Okay, CADC 3, CADC 03 is absent. Now I would like the esteemed panelists to mark the participant. Ma'am, if the marking has been completed, I would like to call the next participant.
I'll be needing a second, please. I'm marking.
Okay, okay.
You can please call the next contestant.
Thank you, ma'am. Now I would like to call CADC 06 to present their argument. CADC 06. Okay, CADC 06 is absent. Now I would like to call CADC 05. CADC 05, please open your camera and mic. CADC 05, please open your mic.
Am I audible?
Yes, you are. Okay,
Okay.
wait a second, I will start the timer.
Okay, no problem.
Okay, now your time starts now.
Okay. Power that is unchecked, even in the name of justice, can quietly undermine democracy. न्याय जरूरी है, लेकिन जब न्याय के नाम पर शक्ति बढ़ जाए तो उस पर सवाल उठाना भी जरूरी है. Respected chairperson, honorable judges, my worthy opponents and dear friends, today I stand against the motion that judiciary should have the power of judicial review. At the first glance, judicial review appears to be the guardian of constitution, protection of rights, and a system where we shield against misuse of power. But when we look deeper, a critical concern emerges. Does judicial review really strengthen democracy, or does it shift away the power from people? I firmly argue that it does the latter. It disturbs the very core principle of democracy. Democracy is built on a simple foundation. The people govern themselves through elected representatives. Parliament reflect will of millions. Judges do not. When courts strike down laws, they are effectively overriding a democratic mandate. It creates a system where the elected authority becomes secondary and the unelected authority becomes the final. This is not a balance. This is a clear shift of power from people to the judiciary. Even when, like in British India, the problem was never the lack of courts, but the lack of representations. Several acts were introduced, like Rowlatt Act, which allowed detention without trial. But the real issue was never the absence of judicial power. There was lack of democratic representations, lack of accountability. Even strong courts could not fix an undemocratic system. What solution India chose after independence was democracy, not judicial supremacy. Judicial overreach, when interpretation expands its power. Judicial review allows courts to interpret the constitutions, but with the passage of time, interpretation can expand into influence into governments. Courts now begin to intervene in public policies and governance. बेसिकली न्यायपालिका का काम कानून समझना है ना कि सरकार चलाना. This shifts judiciary from interpreter to influencer, disturbing the institutional balance. Judicial review has also obstructed many social progress. After independence, India attempted land reforms to reduce inequality. However, court struck many of these lays, citing down violation of property rights. As a result, the government had to make a first constitutional amendment and introduce the ninth schedule. This clearly shows judicial review did not accelerate justice, but in fact it delayed and obstructed reforms. Lack of accountability. In a well functioning democracy, power must always be accompanied by accountability. This acts as a prevention against misuse of power. Elected representatives, the members of parliament and government, are directly accountable to people. They face elections, justify decisions, answer public opinions, and also are at the risk of losing their powers. This creates a perfect feedback or loop mechanism between the power and accountability. The judiciary, however, operates very differently. Judges are appointed, not elected. They are not directly answerable to people, and they are protected by long tenures and institutional independence. While independence is important, it also means judges are largely isolated from public scrutiny. Judges, through judicial review, judges can interpret the law, invalidate laws passed by the elected representatives, shape the government's influence in public decision making. They exercise significant power over millions, yet do not face the same level of accountability as legislature. This creates a one-sided structure. And when power exists without proportional accountability, the risk is not immediate misuse, but gradual expansion without checks. So question becomes, if judiciary has the final say, then who holds the judiciary accountable? Judicial review introduces subjectivity and uncertainty. Judicial decisions are based on interpretations, but interpretation may vary. Different benches have different outcomes. Judges are also human. They are liable to their personal beliefs, values. This might also be a challenge when judicial review occurs. This leads to inconsistency, unpredictability, and legal uncertainty. It slows down the government process. When laws are challenged, implementations get delayed, policies get stuck, development slows down. Judicial review often becomes a bottleneck, not a safeguard. Our constitution have clear separations of power. The constitution divides roles very clearly. Legislature who makes the laws, executive who implement the laws, judiciary who interpret the laws. But judicial review often pushes court into governance areas, weakening this balance. Strong democracies rely on political accountability. A healthy democracy already has elections, oppositions, media, public debate. These are direct and immediate checks. Judicial review is, however, indirect and removed from public control. From colonial laws like Rowlatt Act, where the real issue was lack of representations, not the lack of courts, to 1951, an amendment forced by judicial obstructions of land reforms, and modern concerns about judicial accountability. History shows that judicial review can expand judicial power, delay reforms, and disturb democratic balance. In conclusion, I would like to say judicial review may be intended as a safeguard, but in practice, it risks becoming a tool of overreach. a source of delay, a challenge to democratic authority. In the end, this debate is not about courts or parliament alone. It is about preserving the balance. Because the moment one institution becomes supreme, democracy begins to lose. Democracy must trust its people democracy must trust its people upon all. Justice must guide democracy, but it's never replace the voice of people. Thank you.
Okay, now I would request the esteemed panelists to mark the participant.
To know ki how much time the CADC 05 has taken.
Ma'am, 7 minutes.
Okay. We can continue. I have marked.
Okay, thank you, ma'am. Now I would like to call CADC 08 to present the argument. CADC 08, please open your mic and camera.
Yes, ma'am. Am I audible and visible?
Yes, you are. Your time starts now.
Okay. Every tyrant in history had a parliament, but not one of them had an independent judiciary. Sochi. Good morning, honorable judges, professors, and my fellow delegates. Today, we are all gathered here to discuss on the topic whether judiciary should have the power of judicial review or not. But I think of it as this has been dressed up as a question about law. It is not. It is a question about survival. The survival of the every single right in the Constitution of India that promises to the citizens for the first time in century that they mean something. Consider a situation where tomorrow the parliament passes a law that stripes down the minorities from the right to own property, women from the right to vote, and many more. Who stops them? What if a police officer and executive detains journalists from without charge, without trial, without reasoning? Where does a journalist go? What if the parliament passes a law? Parliament amends the right to vote. Who stops them? Judicial review. Honorable judges, there is no wonder that Dr. B.R. Ambedkar said that Article 32 is the soul of the Constitution, not because he was being poetic, because he understood something that my opponent today have chosen to forget. A right without a remedy is not a right. It is a lie, a sweet lie told to the citizens. You can write, the right to equality is the most beautiful poetry written on the finest piece of paper in the world. If the parliament passes a law tomorrow, that undoes it. Who says that this is void? Who stops them? None. Rather, none. Through this, you have given the powerful a choice, which they honor when convenient and not when not. When you have given them a sentence and a document, and our forefathers make a constitution, not a document. The difference between a constitution and a document is judicial review. Remove it, and you have reformed reformed the constitution. You haven't reformed the constitution. You have repealed it. Honorable judges, let me remind you of the darkest chapter in the history of India, 1975, the emergency, when the judicial review was tested to its fine absolute limit. 1 lakh Indian students, teachers, journalists, father, son, sat in jail. No trial, no reason. With trembling hands and eyes full of hope, they reached for the one thing the Constitution had promised them: justice. They walked to the doors of judiciary. They knocked, not as rebels, not as revolutionaries, rather as citizens, trusting completely that the Constitution meant what it said. The government-owned Attorney General Nirinde stood before the five judges bench in the Supreme Court and said, even if the police officer killed a person out of personal vengeance, there would be no judicial remedy as long as the emergency lasts. 4 judges agreed, but one stood against him. Justice H.R. Khanna. He knew what it would cost him. Before delivering his judgment, he told his sister, I have prepared my judgment. It is going to cost me the Chief Justiceship of India. He delivered it anyway. The government suspended him, appointed a junior judge as CJI. Outraged, Dr. Khanna resigned the same day. The New York Times article written in 1976 about the Indian judge said this: the submission of an independent judiciary to an absolute government is the last step of the destruction of democratic society. And my opponents want to take that last step and expect this assembly to applaud and path a way for them. I want to address the opposition directly. They will argue that the judicial review is undemocratic. How can an unelected judge override the elected member of parliament? It sounds reasonable and it is strong at its own term. I will show you exactly why. Parliament exists because Article 79 of the Constitution created it. Parliament's power to make law, Article 245. Parliament's authority over subject, the 7th schedule. Every atom of the Parliament's power, the Constitution grants it. At the same time, the same Constitution, the same document, the same ink, the same framers gave Article 13. Any law violating fundamental right is void. Article 32. Every citizen may approach the Supreme Court for enforcement. Dr. Ambedkar called this soul itself. Article 142. The Supreme Court may pass any order necessary for complete justice. Article 226. High Court empowered the issue writs against any authority, including Parliament. The Constitution didn't create Parliament. It created conscience for Parliament. They and gave judiciary the power to speak it. So when the judiciary strikes down an unconstitutional law, it does not override Parliament, the Constitution overrides Parliament. The judiciary is simply the instrument through which the Constitution speaks. My opponent are not defending democracy. They are defending a parliament with no ceiling. And a parliament with no ceiling is not democracy. It is the most dangerous thing in any legal system. The power
I request the esteemed panelists to mark the session. And now I would like to call CADC 07. CADC 07, please open your mic and camera.
Am I audible?
Yeah, you are. Okay, now your time starts now.
Okay. Honorable Chair and respected members of this House, let me begin with a simple truth. Power is necessary, but unchecked power, that's dangerous. As Montesquieu once said, there is no liberty if the power of judging is not separated from the legislative and executive powers. But today, we are no longer dealing with simple separation. We are dealing with expansion. And that is exactly why I rise to oppose this motion. Our constitution was built on balance. The legislature makes laws, the executive implements them, the judiciary interprets them. Simple, balanced, structured constitution. Judicial review through Articles 13, 32, and 226 was introduced as a safeguard, not as a takeover. And yes, Constitution gives courts the authority to protect fundamental rights, but nowhere does it say that one institution should become so powerful that it starts overshadowing the others. Because the moment balance disappears, institutional conflict begins. Let me be absolutely clear. I respect the judiciary. It protects rights. It upholds the constitution morality. But as B.R. Ambedkar wisely warned, however good a constitution may be, if those who are implementing it are not good, it will prove to be bad. Because no institution is above human error, and yes, that includes the judiciary too. संविधान ने संस्थाओं को टकराव के लिए नहीं बल्कि संतुलन बनाए रखने के लिए निर्मित किया था. My opponents will say judicial review protects democracy, limits power, and ensures the rule of law, and I agree with one important condition. Limiting power should not mean relocating power to one institution because, as James Madison warned, the accumulation of all powers in the same hands may justly be pronounced the very definition of tyranny. And that warning applies to every institution, even the judiciary. In a democracy, legitimacy comes from the people. As Abraham Lincoln famously said, government of the people, by the people, for the people. But when courts repeatedly strike down laws, reinterpret policies, and continuously expand their own authority, we must ask, are we fully governed by the people or partially by interpretation? Because there is difference between protecting the constitution and controlling the constitutional conversation itself. And this debate began almost immediately after India became a republic. In A.K. Gopalan versus State of Madras, 1950, the Supreme Court interpreted fundamental rights very narrowly while dealing with preventive detention. That case showed something important. Judges too can interpret the Constitution differently depending on the time, the bench, and the circumstance. Then came State of Madras versus Champakam Dorai Rajan, 1951. The court struck down caste-based reservation introduced by the government, saying they violated fundamental rights. The result? The parliament had to bring first constitutional amendment. And that moment proves something very crucial. In a democracy, constitutional interpretation cannot become a one-way street control entirely by one institution, because when unelected institutions repeatedly override elected policymaking, tension between constitutional organs become inevitable. Now, let us talk about accountability. Judges are not elected. They do not have to face public elections. They cannot be voted out by citizens. Yet, they possess the authority to overturn laws passed by elected representatives of millions. जब जिम्मेदारी कम हो, ताकत ज़्यादा तो परेशानी तो होगी ही. And this concern is no longer theoretical. Today, courts are increasingly entering technical and administrative domains that were traditionally left to the experts and institution. Sometimes academic matters, sometimes recruitment systems, sometimes policy implementation. And slowly, judicial review begins turning into judicial supervision. This creates a serious constitutional issue because every institution has its own expertise. Public service commissions under Article 315 to 323 were specifically created to conduct fair recruitment and examinations. Experts exist for a reason. Judges are experts in laws, not necessarily in economics, science, administration, or technical evaluation systems. हर काम का अपना माहिर होता है और जब सब एक दूसरे का काम करने लगे तो पूरी व्यवस्था तमाशा बन के रह जाती है. And once institutions begin crossing these boundaries, governance slows down, finality disappears, and uncertainty increases. Now, let us talk about efficiency. India currently has over 5 crore pending cases left. 5 crore! As William Edward Gladstone rightly said, justice delayed is justice denied. We are expanding judicial intervention into more and more areas instead of reducing backlog. काम कम नहीं हो रहा है, बस दायरे बढ़ते रह जा रहे हैं. Now the other side will say judicial review protects rights, and yes, it absolutely does, but let us also be honest. Rights are protected not just by courts, but also by elections, parliament, media, federalism, and civil society. कोर्ट अकेला पूरा तंत्र नहीं होता. A democracy cannot survive if every constitution question has only one final voice dominating the conversation. And history itself teaches us that no institution is infallible either. That is exactly why the Constitution created balance, not supremacy. Because power without accountability always carries risk. And before I conclude, let me leave this house with a thought. गौर से सुनिएगा. जब एक ही हाथ में सारी ताकत आ जाती है, जब एक ही हाथ में सारी ताकत आ जाती है, तो आवाजों की कीमत धीरे धीरे खो जाती है. और जिस मुल्क में सवालों से ज्यादा सिर्फ फैसले सुनाए जाएं, समझ लीजिए वहां इंसाफ नहीं, सिर्फ हुकूमत रह जाती है, सिर्फ हुकूमत रह जाती है. So, what are we really saying today? Not remove judicial review, but limit it. Keep it where it belongs, protecting fundamental rights, checking illegality, ensuring fairness, not running as governance, acting as policymakers, or becoming the dominant branch of the state. In conclusion, judicial review in its limited form strengthens the democracy, but in its expanded form, it creates imbalance,
Participant, only 1
uncertainty,
minute is remaining.
inefficiency, and lack of accountability. लोकतंत्र तब मजबूत होता है जब पावर डिस्ट्रीब्यूट होती है, कॉन्सेंट्रेट नहीं. एंड राइट नाउ दैट कॉन्स्टिट्यूशनल बैलेंस इज स्लोली ड्रिफ्टिंग अवे राइट इन फ्रंट ऑफ आवर आईज. A democracy survives not when one institution becomes supreme, but when every institution is within its limits. And therefore, I stand firmly against this motion. Thank you. Dhanyavad.
Thank you. Now I would like CADC08 to present their rebuttal, if any.
Yes, ma'am, we have. Ma'am, my opponent
Okay.
mentioned justice late is justice.
Wait,
Sorry, ma'am.
let me start the timer. Okay, now your time start.
Okay, ma'am. Ma'am, my opponent mentioned justice late is justice hurried. Justice late is justice buried. But isn't justice hurried also justice buried? I agree with my opponent when he mentioned that our constitution is imbalanced. I agree with you. I agree with you. The media, they're TRP hungry. We can see we have cases where money was burning for last 3 years and no media has covered it. A parliament, they're temporary. One temporary government can make laws that can be changed by another parliament. In all this, the one thing that remains intact and fixed is a judiciary and a judiciary for which we need judicial review. And I would ask that you mentioned about elected representatives. So Hitler was elected, Mussolini was elected, their parliament passed law legally, democratically. My question is simple. What in your model would have stopped them? And before you answer, remember that in your model, there is no independent judiciary with power of review. So what stops them? Majority, the goodwill of the powerful? Tell me, what is the mechanism? That's it.
Thank you, participant. Now I would like to call CADC07 to present their rebuttal, if there any.
Yes. So first of all, great speech. Now, you argued passionately about protecting democracy from unchecked parliament, but if judicial review itself keeps expanding without clear constitutional limits, then who protects democracy from unchecked judicial power? Number two, you said the judiciary is merely the voice of the constitution, but when judges themselves decide what the constitution means, what prevents interpretation from becoming judicial supremacy? And question number three, you repeatedly portrayed parliament as a potential threat, but in a democracy, should elected judges ultimately have greater practical authority than representatives elected by millions of citizens? That's it.
Thank you, participant. Now I would request the esteemed panelists to mark both the participants.
Mark them, you can continue with the next.
Thank you, ma'am. Now I would like to call CADC10. CADC10 Okay, he is absent. Now I would like to call CADC09 to present their arguments. CADC09. Okay,
Should I start?
wait. You can start now.
Yeah, you can start.
तो जब श्री कृष्ण ने महाभारत के युद्ध के पहले शांति का संदेश लेकर हस्तिनापुर जाना चाहा, तब उन्होंने सिर्फ एक बात कही थी कि बिना शक्ति के सच का कोई मतलब नहीं और बिना शक्ति के मर्यादा नहीं। लेकिन जब सत्ता के पास सब कुछ होने के बावजूद भी शक्ति पे रोक टोक बढ़ने लगी, तब व्यवस्था कमजोर होने लगी। और उस दिन हमें दो बातें समझ में आई कि जब शक्ति पे रोक टोक बढ़ती है, तब विकास और व्यवस्था दोनों कमजोर पड़ते हैं। Greetings to one and all present here. When democracy stands for one man, one vote, power to the people, your voice, your vote, and together we decide, then when the voice of the nation is meant through its elected leaders, then at the time of framing a constitution, how can we give an unelected body the power of judicial review over those representatives? 1946 से लेके 1950 के बीच जब हम अपना संविधान बना रहे हैं, इतने ताकतवर कानूनों और व्यवस्था की सोच के बावजूद भी क्या हम कल एक ऐसा कानून बना पाएंगे जो बिना रुकावट के लागू हो सके? मैं आप सबसे पूछना चाहूंगा कि क्या हर निर्णय को कानून की जांच की दीवारों से टकराना होगा? In the Emperor versus Bal Gangadhar Tilak under section 124A of the IPC shows that when interpretation power is very strong, it can be used to control voices. This was not just only one case, but there are more such cases where the courts interrupt in between, and it shows that people's right can be affected. 1911 में जब वीर सावरकर को काला पानी की जेल भेजा गया, तब ये साफ दिख गया कि वीर सावरकर जैसे स्वतंत्र सेनानी को भी नहीं बख्शा गया, तो फिर अदालत और पूरी व्यवस्था भी जनता की आवाज को बचा नहीं पाएगी। In the case of A.K. Gopalan versus State of Madras, under the Preventive Detention Act, the court allowed strict detention by taking a narrow view of rules. This show courts are not always perfect protectors, so giving them too much power can be risky in the future. क्या हम एक ऐसा लोकतंत्र बनाना चाहते हैं जहां कल को जनता के चुने हुए नेता भी अपनी फैसले पर पूरी तरह काम ना कर पाए? अगर हाँ, तो सोचिए अगर कल को एक ऐसा देश हो जहां की न्यायपालिका बार बार नेताओं के फैसलों में दखल दे। सोचिए अगर कल को एक ऐसा देश हो जहां वोट तो जनता दे लेकिन अंतिम फैसला कहीं और हो जाए। सोचिए अगर कल को एक ऐसा देश हो जहां का लोकतंत्र धीरे धीरे कमजोर होता दिखे। अरे सोचिए अगर कल को एक ऐसा देश हो जहां की संसद के फैसले बार बार रोके जाए। Just think for a moment that if we will give judiciary the power of judicial review, then in future we may find dispute between property rights and courts decision, dispute between citizens' rights and courts, and maybe dispute between parliament's will and court judgment. When we say that the experts can tell the route, but someone with a larger view decides the destination, then why will we give too much power to the expert in courts to decide the path of a nation instead of an elected representative who will truly represent the people's will? In 1947, as India moved towards independence, under Lord Mountbatten, the core demand of major parties during the Partition Council meeting and the implementation of Indian Independent Act was clear. That governance must be in the hands of few elected leaders, not controlled by another institution. अरे अधिकार अगर जनता से दूर चला जाए तो जनाब लोकतंत्र सिर्फ कागज पर रह जाता है. As Bal Gangadhar Tilak once said, that the rights of people must be protected through their own voice, and in a democratic country, the voice of their people is their own representative. There were pre-independence incidents as well. If we will talk about Rowlatt Act or Government of India Act or Indian Council Act or Cabinet Mission Plan, they all were different, but they defined one same thing, that the governance works better with the help of an elected representative rather than a single powerful body. On 15th August 1947, Jawaharlal Nehru once dreamed of a nation where strong and united India could be governed with the help of elected leaders. मैं आप सबसे पूछना चाहूंगा कि क्या हम वैसा भारत का लोकतंत्र बनाना चाहते हैं जहां जवाहरलाल नेहरू का सपना पूरा ना हो पाए? स्वतंत्रता के संघर्ष से लेकर विश्व के सबसे बड़े लिखित संविधान के निर्माण तक, पुरानी परंपराओं से लेकर आधुनिक भारत के सपनों तक, प्राचीन विचारों से लेकर वैज्ञानिक प्रकृति की नई उम्मीदों तक, हर चीज बदलती रही, लेकिन एक सवाल आज भी वही खड़ा है कि कानून की जांच कहां तक जानी चाहिए? आर्टिकल 13, आर्टिकल 32, आर्टिकल 226 already give important power to courts to protect rights, so giving even more power to judicial review can disturb the balance between institutions. इन उर्दूवी से जब फैसलों पर सिर्फ अदालत का ज्यादा दबदबा होता है तो अवामी नुमाइंदों की ताकत धीरे धीरे कम हो जाती है. which means when mostly decisions are controlled by court, then the power of elected representative slowly becomes weak. On 13th April 1990, Jallianwala Bagh massacre took place where General Reginald Dyer ordered firing of innocent people. Later, during the Hunter Commission, C. Shankaran Nair trying to bring out the truth, but full justice was not given. This shows that when power is concentrated, truth can be suppressed, so giving too much final power to one institution can be risky for our democracy. Later, on 8th August 1940, the August offer was announced where the British tried to give limited power but kept final authority with themselves. अरे जब शक्ति पर शुरू से ही इतनी रोक टोक हो जाए कि जनाब वो लोग अपना काम ही ना कर पाए तो सवाल शक्ति पर नहीं उसकी व्यवस्था पर उठता है जो कि उससे जवाब मांग रही है. When power rests too much in judicial review, sometimes truth can be suppressed. लोक सत्ता सर्वाधिक महत्वपूर्ण भवति सदा, which means the power of the people is always the most important. In 1215, when John of England had too much power, people forced him to accept the Magna Carta to limit his authority. This was not about courts, but it showed that when power is concentrated in one place, balance is lost. So in any system, giving too much final power to one body can be risky. अरे जनाब जब चुने हुए प्रतिनिधि कमजोर पड़ते हैं तो जनता की आवाज धीमी होती है और लोकतंत्र का असली मतलब भी कमजोर होता है. On 9 December 1946, in the first meeting of Constituent Assembly, Dr. B.R. Ambedkar and Muhammad Ali Jinnah both spoke about building a strong constitutional system where institution works together and elected representative remains center of democracy. अब अंत में जाते जाते एक लाइन से समाप्त करना चाहूंगा कि जब शक्ति हो बेहिसाब तो फैसला हो जाता है खराब, जब हर कदम पर हो निगरानी तो काम बन जाता है कहानी, जब फैसले पर हो हर वक्त सवाल तो रुक जाता है हर ख्याल, और जब हर ताकत पर हो नजर तब धीमा पड़ जाता है असर. थैंक यू. जय हिंद, जय भारत.
Thank you, participants. Now I request the esteemed
How
panelists to
much
mark
time
the
has this participant has taken?
ma'am 6 minutes 48 seconds.
Okay.
Ma'am, if marking has been completed, I would like to call the next participant.
Give me a second, please.
Okay.
Ma'am, like I have a question, like if we will speak lower than 8 minutes, then will be demarked.
Criteria was given for 8 minutes, so I'll be marking on that basis.
Oh, okay.
Okay, you can continue. Anusha, you can continue.
Okay, ma'am. Now I would like to call CADC 12. CADC 12. Okay. CADC 12 is absent. Now I would like to call CADC 11.
Ma'am, may I start?
Wait a second.
Okay.
Yeah, you can.
Honorable judges, worthy opponents, and members of the House. Power has never entered history as announcing itself as a tyranny. It has always entered quietly, carrying the language of necessity, order, and protection. Every authority that later dominated people by the means began as an answer to chaos. And that is why the question before us today is not whether judges are intelligent or sincere in their hearts, but whether we are designing a constitution capable of restraining power, even if sincerely believes it is right. So, I would like you all to imagine a city, an urban city filled with riches, and everyone has completed their needs. But one bad thing about it was that it was constantly devastated by fire. So, the people thinking one thing in mind, in response, the people created a fire authority filled with experts, engineers, and professionals. The only task they were filled with was ensuring safety of the people. At first, the authority inspected buildings, then it moved to the construction methods, then it decided where the people may live, and so on. Eventually, it announces that no decision of the elected city council is valid unless the fire authority themselves analyzes and certifies it. When citizens protested, they were told calmly and convincingly that this is for their own safety. The city was now secure, but was now not under self governing. Ladies and gentlemen, this is not a fantasy, but the actual constitutional danger we are flirting with when we discuss judicial review without any type of limit. Let us begin with England, because England, though may have ruled us for more than 200 years, understood this danger clearly. In 1610, in Dr. Bonham's case, Chief Justice Coke made a bold claim that courts could only declare acts of parliament void if they were against common right and reason. This is an irony because one unelected judge asserting the authority to override the will of millions of people's representatives. And what did England do? Of course, it celebrated this triumph for liberty, but the parliament rejected it. Parliament reasserted its supremacy, judicial independence was preserved, but judicial supremacy was denied. This distinction mattered. England gave its judges security of tenure so that they could resist the crown, but it never allowed them to overrule the parliament. The result was not oppression, the result was stability. Rights were exempted, but now expanded politically, not judicially. The English understood something we must not forget. A court that can overrule the legislature without accountability does not merely interpret the law, it competes with democracy itself. Now, let us turn to the United States, the birthplace of judicial review and where it took its most dramatic form. In 1803, Marbury versus Madison established the power of courts to strike down legislation. History calls this a masterstroke, but what followed should question us because once courts became the final arbiters of constitutional meaning, they do not always find liberty. Sometimes they also settle for injustice. In Dred Scott versus Sanford, 1857, the United States Supreme Court declared that black people could never be citizens and that Congress revised the power and lacked the power to restrict slavery. This was not legislative tyranny. This was judicial supremacy. This was 9 unelected men freezing moral wrong into constitutional doctrine, and the nation paid for it in blood. If anyone here believes that judges are immune to ideology, the answer is the case of Dred Scott. If anyone believes judicial review is automatically progressive, history disagrees. And the problem did not end there. In the early 20th century, American courts repeatedly struck down social welfare legislation under the banner of freedom of contract of the people. In the infamous case of Faulkner versus New York of 1905, a law limiting the working hours in bakeries was invalidated. Not because the Constitution clearly admired it or demanded it, but because the judges believed that the law interfered with economic liberty as they personally understood it. For decades, courts blocked minimum wage laws, labor protections, and social reforms. Millions of people suffered while democracy was told to wait for the people. But judicial review did not protect the vulnerable, it chose to protect the power. And when economic collapse finally forced the American government to act, courts again resisted until political pressure was put on them and forced them to retreat. The lesson is unmistakable. Judicial overreach does not announce itself as overreach, it announces itself as a principle of the Constitution. Now, let us bring this discussion home. As we are drafting the Constitution of India in the aftermath of colonial rule, for decades, our final court sat in London, 2,500 miles away. It was composed of learned men, it spoke in reasoned judgments, it followed procedure, and yet it was profoundly unjust not because it lacked intelligence, but because it lacked the accountability to the people that it governed. Let us leave that talk for a second and examine the imbalance that we are designing. Members of the parliament face elections, governments fall through no confidence motions, executives are questioned daily by the opposition, laws are debated, amended, and repealed. But judges appointed, not elected, enjoy tenure, insulation, and removal procedures under Article 124. Strode stringent,
Participant, only 1 minute is remaining.
they are nearly impossible to invoke. And where is the symmetry? A constitution that allows every institution to be checked except one is not balanced, it is titled. No institution should be the final judge of its own limits. Court must interpret laws, not govern. They must restrain access, not replace democratic choice. The moment interpretation became supremacy, democracy contracts. What happens when a court strikes down land reforms legislation passed by the poorest citizens? Where do those citizens go? Back to the court that rejected them? What happens when judges begin issuing directions that resemble policy rather than interpretation? Who draws the line? And more importantly, where is their right written? If we forget that today, the future
Participant, your time is completed.
Okay.
Ma'am, I would like to know if you have marked the participant.
Yes, I have marked him.
Okay.
You can continue with the.
Okay. Now I would like to call CADC 14. CADC 14. Please open your mic and camera. Please open your camera as well.
I'm audible.
Yeah. Please start.
Should I start?
Yes, you can.
Courts speak through judgment, and judgment shape society. Honorable judges and worthy opponents. The Constitution is the soul of our nation, but the soul without body cannot act, and the body without soul cannot feel. Judicial review is the heartbeat that connects soul and body of the nations, soul and body of the nation. And this idea reflects strongly the view of Dr. B.R. Ambedkar and Jawaharlal Nehru, who emphasized that the Constitution is the foundation and guiding spirit of country. With this, I stand firmly for the motion the judiciary possess the absolute power of judicial review. To set the stage, I refer to the Professor M.P. Jain, who defines this power as the interposition of judicial power to prevent the violation of the supreme law. With this, a democracy without judicial review is like a car with an accelerator but no brakes. It doesn't matter how fast you go if you are heading with a cliff. With this, I want to cite the view of Justice Sheikh Shah of the judicial review that he said judicial reviews on constitutional amendment, judicial review on legislative action, and the judicial review on administrative action. And judicial review on constitution and amendments, it involves the review of amendments made to the constitution to ensure they are in the line of basic structure and the principle of constitution. And the legislative action, this include the review of law passed by the parliament, state legislation, subordinate legislation. The court examines these laws to determine if they are accordance with the constitution. And also the administrative action, this involves the review of the actions taken by the union, state, and authorities under the state. The court assesses these actions to ensure they are lawful and constitutional. With this, the impact on the present condition of the democracy, and it's protecting the spirit of law, equality, without arbitrariness and without abuse of power. And it's only the tool that protects suppressed class in the in the society and in the nation, and the people who do not raise their voice against their fundamental rights will be violated, and it's come under the fundamental rights of the Constitution, Part 3rd, and also the Article 13 will ensure that any Article 32 and Article 226 give Supreme Court and High Court that if the rights will be violated, then he give the writs on the court. And with this, I also cite the case of Marbury versus Madison 1803, where to establish that it is the empathetic province of the court to say what the law is. This proved that judicial review, the power of interpretation. Without it, the legislature becomes the judge, its own limit, and the constitution becomes that. With this, this is the seal of soul. With this statement of the seal of soul, I want to say that Parliament has the power to prune the branches of our constitution, but they are lack the mandate to uproot the forest. I said the case of Keshavanand Bharti versus State of Kerala. It is a landmark case in our Constitution Assembly, where a 13 judges bench ruled that the Parliament cannot use its amending power to destroy the basic structure of the Constitution. This proved that the judiciary abused the power of preservation. It ensured no political majority can ever vote away over the fundamental existence as a republic. And the last one, and the third principle will be golden balance. A thief cannot allow to write the laws for the police. A limited power cannot grant itself unlimited authority. I said the case of Minerva Miles versus Union of India, 1980, where the court struck down a law that tried to ban judges from reviewing constitutional amendments. This proved that the judicial review was the power of balance. If the legislature can review, is the golden thread that keeps control constitution for become uncontrollable. And the last one, in the modern era, we have to see the judicial review in the modern transparency. In this, transparency is the oxygen of democracy. The court will not allow the government to suffocate the voter in the dark. I said the case of electoral bond case 2024, where the court struck down on anonymous funding scheme to protect the voter right to know. And this proved that the judicial review has the power of legitimacy. It ensured that even the most complex financial policies must yield to the fundamental right of the common citizen. With this, I want to state that the guidelines are given by the bulldozer justice. This is the executive cannot replace gavel with the bulldozer. The home of a citizen is protected by law, not by the political favor. And I said the bulldozer justice guidelines 2024, where the court stopped executive from bypassing trials and demonizing homes. This proved that the judicial review is the power of protection. It is final wall of ordinary citizen and the arbitrary mind of the state. In the conclusion, I want to say that my opponents may call it a power of interference, but I call it insurance. A Chief Justice Dhananjay Yashwant Chandrachud maintains the court it is a sentinel on the Q wave, the guard who never sleeps and always alert and protect the rights of the citizen and also the nation. And the class will not raise their voice against their actions. It protects the rights of the citizens also. And at the last, I said the executive hold the sword, the legislature hold the purse, but the judiciary hold the scale. And it is a judicial review that keeps the scale from tipping into tyranny. For the sake of constitution, for the sake of every citizen, the motion must stand. Thank you.
Thank you, participant. Now I would like to call CADC 13.
Anusha, how much time she has taken?
Ma'am, she has taken 7 minutes.
Okay. Thank you.
Respected judges, is it fine that I use the latest cases and the amendments made after the formation of the Constitution?
Your voice, can it be a little louder, please?
Yes, ma'am. Ma'am, is it fine that I use the amendments and the latest cases?
Yeah, you can.
Okay, ma'am.
Your participant, your time starts now.
जब कलम खुद को खुदा मान ले तो इंसाफ नहीं होता, चुनी हुई सरकार का अपमान कभी माफ नहीं होता। जब लोकतंत्र के मंदिर पर कुछ चेहरे भारी होने लगे, तब समझो कि न्याय के लिबास पर लगा दाग कभी साफ नहीं होता। A democracy under absolute judicial review is like a gilded cage. It looks magnificent from the outside, shiny with the silhouette of justice, but it is a case nonetheless. It is not a shield, but a choking grip that turns the vibrant spirit of 1.4 billion people into a silent frozen statue of judicial approval. As Thomas Jefferson warned, to consider the judges as the ultimate arbiters of all constitutional questions is a very dangerous doctrine indeed, and one which would place us under the despotism of an oligarchy. Respected judges and my opponents who seem to believe that 34 people in black robes possess a divine wisdom that 1.4 billion citizens do not. I am here to shatter that comfortable illusion. Democracy is not a handed down gift by the court. It is the will of the people expressed through their representatives. What my opponents call a structural shield, I call it a judicial stranglehold that paralyzes the nation's progress. I ask you, where was the conscience of the Constitution in 2015 when Parliament unanimously passed the NJAC Act to make the judge appointments transparent? But what did the court did about it? It struck it down to keep the secret club intact. Let me ask you, in what other democracy do the judges get to pick their own successors behind the closed doors? Is this even a judiciary or a self-serving dynasty? Democracy doesn't fall apart with a loud bang. It erodes quietly the moment will of the people is treated as a mistake which is needed to be corrected by an unelected elite. हमें यह समझना होगा कि न्याय की कुर्सी पर बैठा व्यक्ति ईश्वर नहीं होता. If the majority can be wrong, who told you that the small panel of judges is never wrong? The argument is simple. An institution that refuses to be the transparent is an institution that fears the light of democracy. By striking down the NJAC Act, the court didn't protect the Constitution, it protected its own monopoly on power. This is the ultimate hypocrisy. A judiciary that preaches right to information to the citizens, yet operates its own hiring process in a shadow of secrecy, effectively telling 1.4 billion Indian people that their elected representatives are not even qualified to even suggest who should sit on the bench. My opponents love to talk about the conscience of the Constitution. But where was that conscience during the emergency in the ADM Jabalpur case when the citizens begged for their right to life? But the Supreme Court, it looked away and ruled that the state had the license to kill without even a question. When the people cried for help, the shield which was supposed to protect them was used to crush them. If they could decide your life is expendable for political power, why should we even trust their conscience today? My opponents call it judicial activism. But let's be honest, it is judicial overreach. It is a slow takeover that where the judge's preference replaces the people's vote. When the court makes its own rules, it isn't breathing life into the laws. It is sucking out the oxygen out of our democracy. 1.4 billion people are being ruled by the personal opinions of a few individuals. Is this even a republic? No, it's a juristocracy. In the IR Gwalior case, the court used Article 245 and 246 to prove that no law is hidden from them. They effectively told 1.4 billion people, you can make laws, but we have the permanent veto. This is not accountability. It's a judicial hostage situation. Let us be very clear about the limits of power. As Jeremy Bentham noted, Judicial review is a masquerade where the is a masquerade where the judges legislate under the guise of interpretation. We are living in a nihilistic void where the legislature is afraid to act because they fear a judicial veto. आज मैं इस चेतावनी के साथ अंत करता हूं कि लोकतंत्र की असली ताकत बेंच में नहीं बैलेट में है, क्योंकि जज सिर्फ कानून पढ़ते हैं और चुनाव के विजेता लोगों के दिल की बात। थैंक यू।
Now I would like to call CADC 14 for their rebuttal. Your time starts now.
As my opponent said, judicial review ओवररीच करता है और प्रेजेंट कंडीशन में ट्रांसपेरेंसी नहीं है जुडिशियल रिव्यू. So for your kind information, I said to read the present condition of April 2026. There is one case the Rajya Sabha of Odisha, the disqualification of MLAs in the Rajya Sabha because of whip violate, because he violated the discretion of the disqualification. Whip violate because discretion of the Rajya Sabha that he violates. But the Supreme Court only interpret the law and give the review, and he said that in anti-defection law the whip violate only contains the 4 cases. The first one is confidence motion, no confidence motion, money bill, and vote for thanks of president address. So मैं ये कहना चाहूंगी कि सुप्रीम कोर्ट अगर कोई फैसला देता है, अपना इंटरप्रिटेशन देता है, तो वो ट्रांसपेरेंट है. बिकॉज अगर आप प्रेजेंट कंडीशन में देख पा रहे हैं तो राज्यसभा में भी कुछ कानून बने हैं और हमारे पार्लियामेंट में भी कुछ कानून बने हैं, जो लॉज बने हैं वो भी इतनी तरीके से प्रिसाइज नहीं है, इतने डिफाइंड नहीं है, जो उनको सुप्रीम कोर्ट उनको इंटरप्रेट करके बताता है और इस पर फैसला देता है. तो आप ये कैसे कह सकते हैं कि ट्रांसपेरेंसी नहीं है, और वो भी प्रेजेंट टाइम में? प्रेजेंट टाइम ट्रांसपेरेंसी.
Okay.
Participant
So
one-on-one is not allowed.
Okay, okay, sorry.
Your chance will be after 2 minutes. Wait.
Okay, and as my opponent said that कि वोट के थ्रू जो चुनाव के थ्रू जो लीडर्स हैं वो सही हैं, और जो कोर्ट में है जो लीडर्स वो सही नहीं है. Why he said? Because क्या आप मान सकते हैं कि जो
Participant, your time is over.
Okay.
CADC 13. Your time starts now.
Okay, so when I talked about the transparency, I wasn't talking about the judgment of the courts. I talked about their appointment. Like when I talked about the NJAC Act, so I didn't talk about the judgment they gave is not transparent. It is transparent. I talked about their appointment system, which should be fair. So, and for this, I would like to counter your question. If you call Article 32 as a shield for the citizen, but when the court uses it to stall land reforms for the poor, does it not become a sword for the elite? Are you suggesting that the remedy for one wealthy landlord is more important than the justice promised to millions of landless peasants in a preamble?
Are your arguments completed?
Yes, ma'am.
Okay, thank you. Now I request the esteemed panelists to mark both the participants.
I just want to know how much time does CADC 13 has taken?
CADC 13 has taken 7 minutes.
Okay. Thank you. You can continue with the next part.
Okay. Now I would like to call CADC 16. CADC 16. CADC 16, please open your mic and camera. Okay, you are visible.
May I start now?
Yes, you can.
Good morning to the esteemed judges and my fellow participants. I am here to speak for the motion on the topic of should judiciary be allowed to have the power of judicial review or not. I'll start off with the most notable quote of Lord Acton, where he said that power tends to corrupt and absolute power corrupts absolutely. This has been an ailment that political dispensations for centuries been suffering from, where the sovereign attains unlimited and unchecked power over its subjects. As a remedy to this ailment, the modern political constitutional democracies came up with the concept of judicial review, a concept where the courts get to decide, not decide, but courts get to examine if the laws framed by the legislature are conforming to the aspects of supreme law of the land, and if not, they will be voided. In the early 1800s of the United States, in the landmark case of Madison versus Marbury, this concept of judicial review was first instituted. Since then, it has traveled far and beyond. It has also reached India. In the 1950s, when the people of India gave to themselves the ultimate and most sacrosanct document called the Constitution of India. In the 1951, in the landmark A.K. Gopalan case, where the judiciary and our first Chief Justice of India, Justice Kania, said, and I quote, that every law, every statute by the legislature will be tested and examined on the touchstone of the Constitution, because Constitution stands as the supreme law of the land. And if found not conforming, it will be void, and it will be based upon the judicial. It will be based on the judiciary to examine whether it does so or not. 2 years hence, in the year 1952, in the V.G. Rao case, another landmark case, the then Chief Justice of India, Justice Patanjali Shastri, stated that unlike the American judiciary, which has obtained the power of judicial review through the cover of due process clause, the Indian judiciary finds it explicitly mentioned in the Indian Constitution, the power of judicial review. The Article 32, which provides the Supreme Court to issue writs in order to protect the fundamental rights of the citizen. Article 131, which says that the Supreme Court will be having the original jurisdiction to resolve state and center disputes. And Justice Patanjali Shastri also went on to say that when the judiciary exercises this power of judicial review, it is not being a messiah to deliver justice to the people. It is only doing its constitutional obligation. This concept of judicial review has been instrumental in securing to the people of India their fundamental rights. In the landmark case of Menka Gandhi, 1978, when the judiciary not only secured fundamental rights, but also broadened the scope and the horizon of judicial review from the procedure established by law, where the executive exigencies were being challenged, were being tested. Now we have reached and widened up to the concept of due process of law, where along with the executive, the judiciary the legislative too will have to be on its toes while framing laws. Otherwise, the same laws will meet the dead end in the Indian judiciary. Also, talking about the landmark case of S.R. Bommai of 1994, where the Indian judiciary made a very big contribution by clarifying the clouds that had casted aspersions on the very federal structure of the Indian state. Also, in the E.P. Royappa case, the judiciary landed upon the concept of unarbitrariness, saying and stating that arbitrary power, arbitrariness will arbitrariness in legislation will ultimately lead to majoritarianism. That too needs to be curbed, and that power now lies upon the judiciary to do so. Talking about a very widely acclaimed principle called the rule of law, a very strong and very important pillar of the same being the concept of predominance of legal spirits that envisions a capable and independent judiciary to challenge and examine the laws framed by the executive and the legislations. Also, the concept of the principle of natural justice, which envisions the uh, the concept of reasoned decisions, which envisions a hierarchy among the courts, and also a court of record that has that that is able and that is capable of setting precedents for the coming courts to follow. For me, it is it will be nothing but oxymoronic if any other authority gets to judicially review the laws, because it is only the judiciary that is apolitical, that does not have to wait for the next election cycle to deliver justice. This separation of powers, another important concept of the principle of natural justice. If the legislature or the executive get into the machinery of judicially reviewing, it will be a very nothing but a fraud on the constitutional landscape.
Participant, only 1 minute is remaining.
Yes. If the executive has the gun, the legislature has the pen. What the judiciary has is reason. Because the people, the subjects of the Indian Constitution, believe on the constitutional morality, is when the verdict of the judiciary is sponsored. Otherwise, it does not have the power of majority. It does not have the power of gun to secure it. But the Indian judiciary still, to date, has time and again secured justice for the people of India. Thank you.
Thank you, participant. Now I would like to call CADC 15. CADC 15. Please open your mic as well.
Hello. Am I
Hello.
audible?
Yes, you are. Wait a second.
Okay.
Your time starts now.
Honorable judges and my fellow parliamentarians, I'll not start with any quote or shairi in front of the House, because our constitution and the future of our generation isn't a playground of poets. Imagine a country where the nation's highest intellectuals have the time to watch and censor a movie despite having an independent censor board. But they take years to solve the problems of a common man. Who cares? Let the common man die. After all, the decision is in our hands, right? Welcome to India, my dear friends, where the Bombay High Court has the time to make a 3-member committee to review the movie Jolly LLB 2, but they don't have time to clear those 5 crore pending cases. And when questioned about delays, as we saw in the 133rd Parliamentary Standing Committee report of 2023 and the Justice J.S. Verma Committee report of 2013, the Chief Justice responded that the judges work for 24/7. Wow, what an irony. Coming back to the first thing again, judicial review. Members, the judicial review which our judiciary is defending, my dear friends, tell me why can't the judiciary remove the section 4 of the anti-defection law, which clearly violates Article 14 of the Indian Constitution? Yes, which we famously found in news recently 4 days back when a prominent youth icon, Raghav Chadda, along with 6 other Aam Aadmi Party members, merged with Bharatiya Janata Party. The Constitution under Article 13, 32 and 226 allows court to strike down unconstitutional laws, but nowhere does it authorize them to create governance, rule the administration, or jump into policy making. Even Baba Saheb Ambedkar was clear that the judiciary would be a protector, not a parallel authority. Yet today, that difference is disappearing. And the very effect is clearly visible when in Center for Public Interest Litigation versus Union of India, 122 telecom licenses were cancelled. In Manohar Lal Sharma versus Principal Secretary, 214 coal blocks were cancelled. Now, who is responsible? Because the executive answers to the parliament, parliament answers to the people. But when the judiciary oversteps, who answers to the nation? We are told that judicial review protects the silence of the constitution. But think deeply. When silence becomes an invitation for interpretation, interpretation becomes an instrument of expansion, and expansion becomes a tool of control. And if you do not believe, then let me tell you about United Kingdom. The Human Rights Act of 1998, the judges can issue a declaration of incompatibility, but they cannot strike down a whole law. Switzerland Constitution Article 190 forbids judiciary to review constitutionality of federal laws. And in China, the power to interpret the constitution and review laws belongs to the Standing Committee of the National People's Congress, a political body, not a judicial one. These above mentioned three countries are considered more civilized, they are considered more moral, and unfortunately, my friends, they are considered better than India. And when questioned on its selection and decision making, the court brought the collegium system in the 4-judge case. The court struck down the 99th Amendment in 2015, which brought a National Judicial Appointment Commission in the name of transparency. So it means that the system is that the judges appoint judges. Wow, I'm fine with it. But I have one condition, that the Prime Minister will also appoint the next Prime Minister. The Havaldar of the police will also appoint the next Havaldar. If that system works, then there should be transparency in the system, isn't it? Leave everything for one moment. Is the judiciary so insecure that they remove the whole topic of judicial corruption from class 8 NCERT? Literally, they fear 8th class students. Even numerous institutions have also warned us that the Law Commission of India, the National Commission to Review the Working of the Constitution, and the Second Administrative Reforms Commission, the 230th Law Commission report of 2009, all cautioned us against judicial overreach. I'll tell you what, a very major problem with the court is that they solve the problem, but they do not tell how to execute that solution. For example, in 2020, in the middle of the pandemic, the Supreme Court ordered the clearance of 48,000 slums as they were concerned about the garbage on railway tracks. They did not give any order for the relocation. I repeat, they did not give any order for the relocation. 48,000 families became homeless within moments. Now, tell me, where is the right to life? Where is the right to property? The court thinks that they can rule the country by sitting in those air-conditioned rooms, saying they have wisdom. However, honorable members, this is not an argument for dismantling the judicial review. It is an argument for restoring its balance, because the solution is not the absence of a referee, but a referee who remembers the boundary between regulating the game and playing it. First, there must be clear doctrinal limits on judicial expansion, ensuring that the courts interpret the law but refrain from routinely stepping into policy making and legislative domains, except in cases of absolute necessity. Second, we must introduce institutional accountability mechanisms, whether through a reformed and transparent appointments process or an independent oversight framework, so that judicial independence does not translate into judicial insulation. Third, Parliament must reclaim its role by ensuring time-bound legislative responses to judicial directions, so that the courts are not compelled or tempted to fill every vacuum that governance leaves behind. क्योंकि अगर न्यायपालिका ही लोकतंत्र को कटघरे में खड़ा कर दे तो जनाब सत्यमेव जयते सिर्फ दो शब्द बन के रह जाते हैं और जन गण मन में जन और गण की आवाज दबा दी जाती है.
Participant, 1 minute is remaining.
I leave you with the final question. Do we want a democracy governed by the will of the people, or one where every decision ultimately awaits judicial approval? Judicial review was meant to be a safeguard, but today it risks becoming supremacy. And in a democracy, no institution, however noble, can be allowed to rise above the people. Thank you.
Thank you, participant. Now I would like to call CADC 16 for their rebuttal. CADC 16.
Participant said his narrative was about bringing accountability to judiciary, and I definitely agree to that. There are many things that the judiciary can work upon and can get better at, for sure, no doubt in that. But he said that the judiciary should reflect the will of the people. But judiciary was not supposed to be there to reflect the will of the people. It was there to protect something that was changed, but at the same time should have remained eternal. That is the constitutional morality, the constitutional principle, the constitutional morality of the Constitution of India does not change. If tomorrow the majority religious community of India stands up and asserts itself on the judiciary and commands them to follow their narrative, what does my fellow participant believe? Should the judiciary cave into that one? No. The judiciary is there to reflect the constitutional morality, and the constitutional morality should be there even for the last person, the Antyodaya, the welfare of the last citizen at the last pedestal of the society. Even that individual should be protected, and that can only be left upon the judiciary, because the other two organs, legislature and the executive, are there for the next election cycle, are there for the are political in nature, and are there for the majoritarian narrative. So this is my question and my rebuttal to my fellow participant.
Participant, your time is over. Now I would like to call CADC 15 for their rebuttal.
Okay. So factually, Article 348 of the Constitution mandates that the Supreme Court's proceedings should be in the language English. My question is, in a country where 90% of the population does not use English as a primary language, how can an institution claim to be the guardian of the people when it conducts its most powerful reviews in a colonial language that the people cannot speak? Isn't judicial review just a conversation between elites about the fate of the masses? Okay, so I have another question as well. That in the MC Mehta case, the court used judicial review to shut down thousands of small-scale industries in Delhi and later banned mining in various states. While the review was technically for the environment, the National Council of Applied Economic Research and other bodies pointed to the loss of hundreds and thousands of jobs. By what factual data does a judge determine the balance between a clean environment and a starving worker? Since judges are not trained in environmental economics, isn't their review in these cases just a blind guess? Was just a blind guess with human lives at stake? Okay, so also in the Vodafone tax case, the Supreme Court used its power to interpretation to rule that a multi-billion-dollar offshore deal couldn't be taxed in India. This forced the government to bring in a retrospective tax law, which destroyed India's reputation as an investment destination for a decade. When the judiciary's review creates a multi-billion-dollar tax loophole for a foreign corporation and the parliament has to scramble to fix the damage, who is really guarding the national interest? The court that protected the corporation or the parliament that tried to collect that revenue? Thank you. That's it.
Thank you, participants. Now I request the esteemed panelists to mark both the participants. Ma'am, if the marking has been completed, can I call the next participant?
Yes, you may.
Okay, thank you, ma'am. Now I would like to call CADC 18. CADC 18. Please open your mic as well.
Am I properly visible and audible?
Yeah, you are. You can start.
Honorable distinguished judges and my fellow debaters, imagine a constitution without teeth, a tiger without claws. That's what we are debating today. Constitutional power without accountability is tyranny with a legal stamp. Who guards the guardian when the parliament forgets its limits? Let me ask you this. Can we afford to trust any branch completely? The answer is edged in our constitution itself and sealed by the 7 decades of jurisprudence. It is the judiciary through the ways of judicial review. Let me show you how it is done. Now, let me take you back to the year of 1976. Picture this: emergency declared, thousands detained without trial, habeas corpus, the heart of liberty suspended. And what did our Supreme Court do? In the case of ADM Jabalpur versus Shivkant Shukla, a 4:1 majority said the courts have no power to protect even Article 21, the right of life. The state could imprison anyone, and the judges had no answer. In that panel, only Justice H.R. Khanna dissented. He said, and I quote, even without Article 21, the state cannot deprive liberty without law. But in return, he paid dearly. He paid dearly. He was superseded as the Chief Justice of India. Now tell me, when courts abdicated review, was democracy safer? Or did India live 21 months of constitutional darkness? When the nightmare ended, India was ashamed. In the case of 2017, P.S. Puttaswamy, the Supreme Court itself called ADM Jabalpur. They said, and I quote again, an aberration in our constitutional history. History screams the lesson. Without judicial review, the constitution is a decorative parchment. Can we read that again? Now, secondly, let's talk about conspiracy. A legal escape has built for the parliament built for itself. Article 31B and the 9th schedule were for land reforms. But the parliament stuffed 284 laws there to dodge the review. Laws violating fundamental rights, a constitution-free zone. Enter the case of I.R. Kolo versus State of Tamil Nadu in the year 2007. A 9-judge bench led by C.G.S. Savarwal unanimously ruled that the 9th schedule laws post the case of Keshavan Bharti can be reviewed if they damage the basic structure. Why? Because letting parliament create no judge zones destroys constitutional supremacy. So I ask that if the parliament can hide laws from court, what's stopping tomorrow's majority from shielding abuses? यदि सांसद अपने कानून को न्यायिक समीक्षा से छुपा सकती है, तो संविधान का तो कोई अर्थ ही नहीं बचा. Can you imagine that power unchecked? Here's the genius of our constitution. Judicial review isn't just a tool, it is the basic structure. In the case of L. Chandrakumar versus Union of India in the year 1997, a 7-judge bench declared Article 32 and 226 the heart of judicial review, the heart of constitutional remedies as an essential feature of the basic structure, self-entrenching. Think of it as a power of constitution's immune system. Remove it and there is no defense against arbitrary power. Even amendments can't touch it. एक संविधान जो अपनी रक्षा नहीं कर सकता वो सिर्फ एक कागज है. If you strip away this very power, what protects the constitution from itself? This isn't just a judicial whim, it is a constitutional design. Parliament amends within limits. Courts enforce those limits. A simple question. Without this, who stops constitutional suicide by amendment? So, in my concluding statement, 3 truths for you to chew on. First, the ADM Jabalpur showed India without review, which was darkness. Second, the ninth schedule proved Parliament's self-serving tricks. And third, the basic structure marks review non-negotiable. Ask yourself, do we want a constitution that defends itself or the one that begs for mercy? The motion isn't judicial privilege. It's a citizen's promise against tyranny. Thank you, Jay.
Time stop हुआ थी?
Are your arguments completed?
Yes, ma'am.
Okay, thank you. Now I would like to call CADC 17 to present their arguments.
Yes, am I audible?
Yeah, you are. You can start now.
Dr. B.R. Ambedkar has said that if I find the constitution being misused, I shall be the first to burn it. It means a constitution has value only when it serves justice. If it is misused, it loses its ideals, moral authority, and loyalty must shift from the document to the principle it was meant to protect. Honorable Chairman and respected members of this assembly, I rise today to a place before this House a concern not merely of legal design but of democratic philosophy. If we are adopt a constitution that begins with the words "we the people of India," then we must ask ourselves that can we, in the same breath, create a system where the will of those very people may be set aside by a body that is neither elected by them nor accountable to them. ये सभी संवैधानिक वाद विवाद कागज पर लिखे शब्द नहीं बल्कि ये हिंदुस्तान के नाम को विश्व के सबसे बड़े लोकतंत्र के रूप में देखने के प्रयास है. We are in the process of framing a constitution that already proposes fundamental rights, which are enforceable through which is being envisioned as the right to constitutional remedies under Article 32. The provision gives citizens the power to directly approach the Supreme Court for enforcement of their rights. But while designing such a powerful safeguard, we must ask that are we creating a mechanism of protection or the possibility of institutional dominance? क्योंकि Pandit Jawaharlal Nehru placed immense faith in democratic institutions, the only institutions that derive their authority from the people. The legislature we are creating will be accountable through elections, debate, and public responsibility. The House has carefully framed the fundamental rights under Part 3, but it has equally trusted the democratic process to give them meaning in their practice. If at every stage the final word rests with not elected institutions but with judicial interpretation, then we must ask, are we strengthening our democracy or subtly redefining it? क्योंकि शक्ति जनता से आती है ना कि केवल व्याख्या से. Let us also consider the nature of governance. The constitution reflects a clear structure. The legislature to make laws, the executives to implement them, and the judiciary to interpret them. This separation of function is not accidental, it's deliberate. But if interpretation gradually extends into evaluation of policy into decisions involving economic and social considerations, then this separation risks becoming only theoretical. और फिर हम कहेंगे कि न्यायालय ने फैसला दे दिया इसलिए वह अंतिम सत्य है. पर क्या हर कानूनी व्याख्या सामाजिक वास्तविकता का पूरा दर्पण होती है? Dr. B.R. Ambedkar emphasized that our constitution is built upon a system of checks and balances. But checks and balances does not mean that one organ becomes superior. They meant restraint and they meant boundaries. We have also debated provisions ensuring the independence of the judiciary, security of tenure, protection in appointment, and freedom from executive interference. But these safeguards were designed to ensure impartiality, not to create supremacy. यही संतुलन संविधान का असली सार है, जहां हर संस्था अपनी सीमा में रहकर काम करती है और मिलकर एक मजबूत लोकतंत्र का निर्माण करती है. Some may argue that judicial review is essential for protecting fundamental rights. Indeed, rights must be protected. But let us reflect, have we not already created multiple safeguards? We have placed faith in free elections, in a responsible legislature, in an aware public, and in the evolving strength of institutions. The Constitution also introduces the directive principles of state policy, which reflects the social and economic goals of governance. If judicial review begins to overshadow these broader objectives, we risk prioritizing interpretation over transformation. Honorable members of this House, as we deliberate the delicate balance of powers in our next Constitution, let us heed the wisdom of our own distinguished draftsmen from these very proceedings. Dr. B.R. Ambedkar affirmed on 4 December 1948 that Article 32 serves as the heart and soul for enforcing fundamental rights against clear state violations alone, not as a veto over Parliament's economic or social legislation. Sri Alladhi Krishnaswamy Iyer cautioned on 23rd November 1949 against transforming the judiciary into a super legislature that supplants elected representatives. And Pandit Jawaharlal Nehru emphasized on 8 November 1948 that judicial interpretation must yield on the sovereign needs of state necessity. These pronouncements from our recorded debates affirm that sovereignty resides with the people through their parliament, not in the interpretative chambers of unelected judges. Let we unwittingly erect judicial supremacy where democratic accountability was intended. और धीरे धीरे स्थिति ऐसी हो सकती है जहां जनता अपने अधिकारों के लिए अपने प्रतिनिधियों से कम और न्यायालय से अधिक अपेक्षा करने लगे. क्या ये वही लोकतंत्र है जिसका हम सपना देखते हैं? There is also a question on accountability. Members of the legislature must return to the people. They must answer for their decisions, but the judiciary by design does not. And rightly so, independence is essential. But independence combined with expansive power and limited accountability creates a serious constitutional concerns. ये प्रश्न हम सबके सामने है. क्या ऐसी व्यवस्था लोकतंत्र जवाबदेही के सिद्धांतों से मेल खाता है? Let me be clear. I do not argue against the complete absence of judicial review. A limited power confined to ensuring that laws do not violate clearly defined constitutional provisions may indeed serve as a purpose. But what I caution against is its unrestricted expansion. Because once such expansion begins, its boundaries becomes uncertain. और जब सीमाएं अस्पष्ट हो जाती हैं, तब शक्ति स्वयं अपनी सीमाएं तय करने लगती हैं. We must also remember that a written constitution not merely distributes power, it defines its limits. If those limits are themselves
Participant, your 1 minute is remaining.
to continuous reinterpretation, then the certainty of the constitution may give way to the uncertainty of interpretation. So, honorable members, as we craft this constitution, let us remember the beautiful French line, Le autorité finale appartient au people, pass all interpretation. Final authority belongs to the people, my dear friends, through their elected parliament, not to the judicial chambers. क्योंकि लोकतंत्र तब मजबूत रहेगा जब हर संस्था अपनी मर्यादा का पालन करे और जनता का विश्वास सर्वोपरि बना रहे. थैंक यू, धन्यवाद एंड सत्यमेव जयते.
Thank you, participant. Now I would like to call CADC 18 for their rebuttal.
So,
CADC 18 for their rebuttal.
so in my has the time started?
Hello?
Am I audible?
Yeah, you are. Now you are. Your time for the rebuttal starts now.
So, my fellow debater, presented very good arguments, but I would just like to ask some questions. You say that power comes from people. In the parliament, people are elected. In judiciary, they are not. But on the contrary, if the parliament can be trusted, why uh, not let it interpret the constitution itself? You said that they will prioritize interpretation over implementation. Then they will get it's like they are wanting unchecked legislative power. They will frame the citizens' position as anti-rights. Moreover, without judicial review, fundamental rights are meaningless. They will only act as a shield for liberty, but not any other things. And you might also ignore other constitutional safeguards. And also, the main thing to be discussed here is judicial review is a part of the basic structure that was laid down in the case of Keshav and Bharti versus state of Kerala. So we cannot oppose it. That's all.
Thank you, participant. Now I would like to call CADC 17 for their rebuttal.
Yes, my worthy opponent described that in the case of Keswan and the Bharti. So I would like to clarify that the court created a basic structured doctrine over there, but our constitution makers suggested that the responsibility of the judiciary is not to make policies. So this statement cannot be made that the case of Kesavananda Bharti could not be used over here. And also, my worthy opponent talked about emergency during his speech. So I would like to answer that yes, the judiciary failed during the emergency, but the power itself proves that judicial review is not a perfect safeguard. I understand that Justice H.R. Khanna stood for liberty, but he stood alone. That shows the strength of personal integrity, not the reliability of judicial review as an institution. So, my opponent is using an emotional example, but policy making cannot be based on exceptions. It must be based on consistent outcomes. And about the case of L. Chandra Kumar, the judiciary gave more power to itself by restoring judicial review over tribunals. So this raises a concern that who checks the judiciary. Also, my worthy opponent made a statement of elections and the free will of the judiciary. So I would like to clarify that my opponent does not consider the citizens even disabled that they could select their own representatives for their will. Are the citizens not enough mature to select their own representatives to represent their talks in the parliament? So do we need an extra body or extra interference in between the will of the people? That's all for my answers.
Thank you, participant. Now I request the esteemed panelists to mark both the participants.
I've already marked them.
Okay, ma'am, if the marking has been completed, can you give these marking to the student coordinator, Anushri?
Yeah, I'll provide it.
Okay, thank you, ma'am.
Okay.
Respected judge, esteemed faculty members, and my dear participants. On behalf of Amity Law School, Amity University, Madhya Pradesh, I extend my sincere gratitude to all of you for contributing to successful conduct of this preliminary session of the National Level Constituent Assembly Debate Competition. We would like to especially thank our Honorable Judge for her valuable time and insightful evaluation. We would like to convey our deep regards to Honorable Pro-Chancellor Lieutenant General V.K. Sharma Sir, AVSM, Honorable Vice Chancellor Professor Dr. R.S. Thomas Sir, Major General Rajinder Kumar, AVSM, SM, VSM, Director, Amity Law School, AUMP, faculty members and organizers for their constant support and guidance. A heartfelt appreciation to all the participants for their enthusiasm, thoughtful arguments, and excellent articulation on this significant constitutional topic. We also convey thanks to Law Octopus as it was our promotional partner. Lastly, we thank the organizing and technical team for ensuring the smooth execution of this session. With this, we conclude the preliminary round and look forward to the next stage. Thank you. Ma'am, do you want to say any concluding remarks to our participants?
Yeah, it was well researched and very well presented debate. And I wish all the very best whoever goes in the semis and finals. And it is very well coordinated and very well conducted debate competition. I congratulate Amity Law School, Amity University, Madhya Pradesh for this. And thank you for inviting me as a panelist.
Thank you so much, ma'am. We are grateful for your presence. Can I conclude the session now? End the
Yes,
session?
yes,
Thank you,
yes,
ma'am.
yes.